Okay, everybody have a seat. Jurors, thanks for your patience. Here we go. If there's any issue during this length of time that you need a break, just give me the signal and I'll take care of you. We're here to serve you at this juncture. Mr. Pribble, you ready? Go ahead, sir. Good morning.
In a case like this, where we know that more than 22 shots were fired from more than one gun, and where we know that 3 young people's lives were abruptly and violently ended, and where we know that the families of those 3 young people are absolutely heartbroken because of what happened to their loved ones. In a case like this, it is all too easy to let the outcome of the events of February 5th, 2017, the events of that terrible night, to be the lens that we look through when we view and evaluate the evidence in this case. But that lens, looking backward from here where we sit today, at the terrible tragedy that happened more than 2 years ago, that's a lens that can distort, that can corrupt, and can skew our thinking and our decision making. It's through that lens that we tend to not be able to objectively evaluate evidence in a case. It is looking through that lens. 3 people murdered. It's looking through that lens that tempts the human mind to assume the worst and to view every piece of evidence that's presented as evidence of a premeditated intention to commit those murders, regardless of what other reasonable and fair interpretations of that evidence there might be. That sort of conclusion-based reasoning is a type of reasoning that our criminal justice system tries so hard to put in check by requiring scrutiny and deliberation. I heard a judge once describe deliberation as long and careful consideration. You know, going back to jury selection, it started with Judge Marks describing that we have these rules in place. These rules that address a concern that erroneous assumptions of guilt will interfere with that long and careful consideration. And it is out of that concern that the law requires you all to presume innocence rather than to assume guilt. Our justice system has rules that try to counteract the possibility that a terrible event, such as what happened in this case, could encourage jurors like yourselves, who are only human like the rest of us, to take intellectual shortcuts, to make hasty, emotional reactions, to make questionable logical leaps. Because assumptions, speculation, can only lead to one outcome: a miscarriage of justice. And that is why the law places the burden of proof so squarely and firmly on the prosecution. That's why the law has created the highest burden of proof, proof beyond and to the exclusion of every reasonable doubt, the highest burden of proof known to any system of law. And it's why the judge has explained how meticulously and methodically you have to evaluate and scrutinize the evidence in this case, and how carefully you have to decide a verdict for each offense charged. No one in this courtroom envies your position. Under the bright lights of the media, under the watchful gaze of families who are irreparably heartbroken, the decisions you have to make individually and collectively in this case are the most difficult decisions that we make in our system of law. And they're probably going to be some of the most difficult decisions some or all of you will ever make in your entire lives. No matter what your decisions are in this case, I'm sure you all recognize that there will be someone who will disagree with your decisions, no matter what they are. Regardless of your decision, some people will believe you made the wrong decision. But you've been chosen to stand as citizens between Mr. Vasata, Mr. Christopher Vasata, this young man, and the government of our state of Florida in this case. And we've chosen you all to make these decisions instead of anyone else, because we trust in the collective wisdom of a jury of citizens like yourselves to make the right decision after careful deliberation. I want to talk to you about the evidence in this case. You heard the judge say throughout this trial, there's a lot of evidence in the case. And I think what he means when he says that, not to be presumptuous, is that there are a lot of exhibits. I believe there are 330 or more state exhibits, and there are 13 defense exhibits for your consideration. As the judge instructed you, whether the state has met their burden of proof does not depend on the number of exhibits or the number of witnesses that have been presented. Instead, it depends on the nature and the quality of that evidence. And that's in the weighing the evidence instruction, which is in page 34 of your packet. And at the end of the day, you as jurors get to decide whether a particular item of evidence matters at all or not. And if so, how much it actually matters. And just like with the exhibits and evidence, you get to decide whether the testimony you heard from witnesses matters. And if so, how much it matters. Unfortunately, I haven't come up with a perfect way to go through what's kind of become a sort of Rubik's Cube of evidence in this case. There are 3 deceased individuals. There are 3 relevant scenes that were investigated. There are text messages. There are phone records. Dozens, if not hundreds, of photographs, surveillance videos, firearm-related evidence, DNA evidence, and hours of testimony in this courtroom from witnesses while you sat there attentively. Ultimately, each of those needs to be discussed. And at the end of the day, for each piece of evidence, each part of the evidence in this case, you need to ask yourself, what does this evidence tell me about whether the state has proved Mr. Vasata is guilty of any of the crimes charged? Just like we talked about in jury selection, you go through piece by piece and charge by charge to ensure you make a careful and reasoned decision in a case like this. And because Mr. Vasata is charged with 3 separate counts of first-degree murder and a separate count of attempted first-degree murder, for every bit of evidence in this case, you should ask yourselves, how does this help me decide whether Christopher Vasata had a premeditated intention to kill Sean Henry, Brandy El-Sahi, Kelly Doherty, and Charles Vorpagel? And I'm going to ask you to ask yourselves those questions as I go through this, and to ask yourselves those questions and discuss those questions during your deliberations. Now, obviously the least serious offense that Mr. Vasata is charged with is the theft of Sean Henry's automobile. and I'm not going to spend much of my time talking about that. If you believe that Mr. Vasata intended all along to steal that car, even before going to 1105 Mohawk, despite the absolute lack of evidence of that, you are the jury. That is your decision. That's your call. If you believe that after having been shot 2 times in the back with a high-powered rifle to the extent that he could not walk, that Mr. Vasata possessed the physical and mental will to intentionally enter into that vehicle and steal it, despite the evidence showing that he was carried and placed into that vehicle by others who then fled the scene before dumping Mr. Vasata in the street, it's your decision to make. And if you believe it's okay to assume the existence of a criminal intention, despite clear evidence, despite a lack of clear evidence of it, again, that's your decision. Although you ultimately will make your decisions on each separate charge, and you'll base your deliberations charge by charge, I think the most efficient way to go through this discussion with you is to look at each of the different scenes at which law enforcement located evidence and see what the evidence at each scene proves to you about Mr. Vasata's state of mind that night, to see what it tells you about whether his mind harbored a premeditated intention to kill, and to see if he, in fact, himself killed anyone. Now, when the police arrived at 1105 Mohawk Way, they arrived to the aftermath of what had obviously been a chaotic scene. We heard from Mr. Vorpagel that the scene went from silence to gunshots and chaos, and then back to silence again in a matter of seconds. There were no screams, no yelling. The neighbor to the east, who said he could always hear the conversations when Mr. Vorpagel and others were around the fire pit, said he didn't hear anything before he heard the gunshots. As the first responders approached the house, they encountered darkness. You can see from multiple photos and evidence, including this is Defense Exhibit 3A, 3B. We see that the blinds are drawn on the front windows. Cannot see inside. You cannot tell who, if anyone, is home. There are no lights illuminating the front of the house. There's a small dark-colored sedan, not unlike Mr. Vorpagel's Audi, parked next to where Sean Henry's car was parked. The state has said that Mr. Vasata knew that Mr. Vorpagel had gotten rid of his automobile. We as attorneys tell you what we think the evidence is in this case. Ultimately, it's your decision. If you heard any evidence of that, you can rely on that. But there was no evidence that Mr. Vasata knew that Mr. Vorpagel had gotten rid of his car. Nonetheless, there's no obvious indication from the exterior of the house that the girls were present, Miss Doherty and Miss El-Sahi. As first responders navigated around the west side of the house in the pitch black of the back side of the house, they required the aid of flashlights and other forms of artificial lighting. They began to get a sense of who and what was present. You heard from Officer Fandry and Officers Jurak. You heard from the crime scene investigators, McClendon and Bryant, and from, I think, at least Detective Bujanowski, that there was not a single light shining in the backyard area or the patio area surrounding the pool or around the fire pit area. Only with the aid of the light on one of the officers' ballistic shields could officers even make out Miss Doherty's body seated in the chair with her back toward them. You heard it was so dark that Mr. Vorpagel couldn't even see Miss El-Sahi or Mr. Henry when he returned back to the backyard. Mr. Vorpagel talked at some point about a motion sensing light on the northwest corner of his house. It's fairly clear, I think, from the evidence in this case, from the photographs and from the testimony of the multiple law enforcement officers who were struggling to make observations of the scene in the pitch darkness, that light was either not working or was not turned on. With the aid of their artificial lighting, the first responders could finally see there were 3 deceased bodies, and they began to notice shell casings. They found a black Glock pistol, which you will also recall from the testimony of Teresa Bryant, one of the Jupiter crime scene investigators. She says she doesn't ultimately know where any particular piece of evidence landed initially, only that she documented it, as is her job, where it ultimately came to rest before she took her photographs. She says she doesn't know if the shell casings or where they landed after being ejected from the firearms, or whether one or more of them had been kicked or moved unintentionally while first responders maneuvered and trooped through the backyard. Ultimately, the final resting places of each piece of evidence in that backyard was documented in meticulous detail by CSIs McClendon and Bryant. They described that each shell casing, after being marked with the survey flag, was photographed from multiple distance, from far, middle range, and close up. They did that in order to show you exactly what shell casing was at each location. For whatever reason, the state's presentation of evidence has not introduced evidence of where each shell casing was located. So, particularly for the .40 caliber shell casings, and there were 5, not at least 5, there were 5, as documented by the crime scene investigators, you're left to guess. Where were they? Maybe they think that gives them more flexibility in arguing to you or speculating about what may have happened specifically in that backyard. We do have some diagrams that were introduced in evidence, and this is Defense Exhibit 2. It's a series of diagrams. These diagrams were drawn by CSIs McClendon and Bryant. CSI Bryant explained there were 17 shell casings that were found, and then this exhibit, this is Defense 2A. She marked each of those shell casings with an X. She explained that there were 17 rifle shell casings, and that those were found primarily to the south and the southwest of the fire pit, between the fire pit and the house. She didn't testify about where the .40 caliber shell casings were found. I think there's 1 or 2 images which may depict a brass-colored shell casing which came from the .40 caliber. At the end of the day, it is difficult to draw any hard conclusions based off of the location of the evidence as to where each of the shooters were in this case. Omar Felix, you'll remember, firearms expert, told us a little bit about semi-automatic firearms. Told us that the rifle in this case, when it ejects a shell casing, it ejects it to the right. We know that a lot of factors can determine where those casings finally land. Is the person firing the gun moving? What positions are they holding the gun in? Are the shell casings bouncing off of other objects? In a scene like the backyard at 1105 Mohawk, it becomes challenging, if not altogether impossible, to try to piece together exactly what happened from the physical evidence recovered in the case. What conclusions can you draw about the 7.62, the rifle shell casings in the backyard at Mohawk? We know that the person who was firing that rifle, a person Charlie Vorpagel believed was Luke Kasukos, a person whose face Charlie Vorpagel saw illuminated by the larger muzzle flash of the rifle, a person Charlie Vorpagel described as looking and sounding distinctly like Luke Kasukos, a person whose description looks nothing like Mr. Vasata or even Mr. Stewart, but which perfectly matches Luke Kasukos. We know that that person fired that rifle 17 times. The state tells you it does not matter. They tell you it does not matter who fired an assault rifle 17 times in a series of seconds and murdered 3 people with it. Without warning to anyone, including Mr. Vasata. So what concrete, non-speculative evidence did you hear about Mr. Vasata directing Mr. Kasukos to fire that rifle? What evidence did you hear about Christopher Vasata saying anything to Mr. Kasukos, which was encouraging him to begin firing? What evidence did you see or hear to prove that Luke Kasukos' decision and choice to start firing that rifle was the result of anything other than Luke Kasukos' independent decision-making? You didn't hear or see any of that evidence because there is no evidence that that's what occurred. What else do we know about from the rifle shell casings in the backyard of Mohawk? Well, we know they were all fired from the same rifle. Of course they were. There's one rifle in this case. There's one rifle in evidence. There's one rifle that Luke Kasukos used to kill Brandy El Sahi and Kelly Doherty, and to blast high-powered rifle rounds through Sean Henry's torso, fatally damaging his heart. And there's no evidence, other than what the prosecutor can imagine in their mind, that Mr. Vasata intended him to do that. What conclusions can we draw about the .40 caliber shell casings that were found in the backyard? Again, there's 5, not at least 5. We know that all 5 casings were ejected from the Glock pistol with an extended magazine that was found on the ground to the northwest of the fire pit. It shows it in this diagram. It's a red fire. Well, we know that Mr. Vasata's DNA is not found on that firearm. His fingerprints are not found on that firearm. His DNA isn't on the pistol or the extended magazine that's inserted into it. There's no evidence that his DNA or fingerprints are on the 23 unfired cartridges that are in the extended magazine, or the cartridges from the magazine pulled out of the rifle. We all learned during the course of this trial that the state sent swabs taken from the unfired cartridges, taken from the extended magazine, from this firearm, which was fired 5 times in the backyard, and the unfired cartridges from the magazine of the rifle that's recovered in the culvert under I-95, that those were sent to a laboratory called Bodie Labs, an independent laboratory, to test those casings for DNA. During this trial, did you hear about any results of that testing that said Mr. Vasata's DNA was on a single one of those 23 unfired cartridges in the magazine? No. Well, someone took the bullets that were in that magazine, they took them out of a box of bullets with their hands. They loaded those bullets into that extended magazine. Somebody bought the box of ammunition that those bullets came from and touched it in the process. The state may argue, well, they must have used gloves to do that. How is such a claim anything less than speculation? Curiously, the Glock pistol that's found in the back of Mohawk doesn't have any of Mr. Vasata's blood on it whatsoever, despite the fact that Christopher was bleeding profusely. that his blood is in multiple locations in the backyard, on the pool patio at 1105 Mohawk. His blood is splattered on the cast concrete planer. And it's not visible in this diagram, but one of the aids that the state used and some of the photos that are in evidence show that there's between these two trees, and there's actually 4 trees in the photograph. Right here at the edge where the patching line, there's a cast iron, I call it a concrete plant, or something that somebody who actually took care of their backyard might have a nice plant growing in. His blood is splattered, and when I say his, I mean Christopher Vasata's blood, is splattered on that planter, on the west side of that planter. The Glock is found to the south and the east of that planter, the opposite side where the blood is. Ask yourself, what evidence has the state presented that shows beyond a reasonable doubt that Mr. Vasata has ever touched that gun? Outside of speculation and assuming the absolute worst of this young man, despite being instructed to presume innocence, what other evidence is there that says he's ever touched that gun? What evidence is there that he fired that gun? What evidence is there that he fired that gun into the head and body of Sean Henry, killing him? What degree of confidence and certainty can you have in that conclusion? The state's conclusion they want you to draw. When the strongest conclusion that you can draw from the evidence is, I'm not sure. That is not proof beyond a reasonable doubt. Now, I suspect the state will propose that Mr. Vasata's blood is not on the Glock that's found in the grass, because he must have dropped it immediately after he was shot. This is that lens that they're looking for and that they're asking you to look through. What evidence supports that conclusion to the exclusion of other reasonable and fair conclusions? Could that be what happened? Maybe. If you're willing to speculate, yeah, it's a definitely maybe. Could Marcus Stewart have thoughtlessly dropped that gun in a moment of chaos when he grabbed Mr. Vasata to help him out of the backyard? Yep. That could have happened also, right? Based on the evidence presented in this case, can you say that one happened and one didn't? But you're sure of? You're the jury. You get to make these decisions. You get to decide what conclusions you draw from the evidence in this case. You get to decide what lens you want to look through when examining the evidence in the case. Do you want to look through a lens that assumes Mr. Vasata is guilty? You're the jury. You get to decide what to do. We heard about fragments and projectiles that were found throughout this backyard. You heard from the crime scene investigators, they spent 2 days out there, metal detectors, shovels, sifting, doing a methodical job of trying to locate every item of evidence that might matter in this case. We heard from Omar Felix that of the 4 fired yet still intact projectiles that were recovered from the backyard, that's the part of the cartridge. Remember, Mr. Felix told us the cartridge is the shell casing plus the primer, powder, and the actual bullet, which is the projectile. We heard from the CSIs there's 4 projectiles recovered. 2 of those he identified as being .40 caliber projectiles, and 2 he identified as .7.62 rifle projectiles. Now, the state didn't present to you evidence as to where each type of projectile was found within the backyard. I'm not sure why they would neglect to do that. Ms. Ridgestone, I believe, And if I'm misquoting a witness or the prosecutors, I apologize for it. You guys have been sitting through these days of this trial just as I have. You've been taking notes carefully and paying attention. You're going to rely on what you recall having happened. But my recollection of what Ms. Ridgestone attempted to persuade you of a few minutes ago was, she said, there's a .40 caliber projectile that's found under Sean Henry, right? What does this show? We have a projectile here to the left of Sean Henry's body. We have a projectile here to the northeast, some distance from Mr. Henry's body. We have a projectile here. And finally, here's a projectile here. These projectiles were recovered. They were packaged. They were put into evidence. They were preserved, and they were given to Omar Felix. The state can tell you there's a .40 caliber projectile under Sean Henry, but you rely on what the evidence is, not on what the prosecutor says. Ultimately, ask yourself, how does the fact that two .40 caliber projectiles and two rifle projectiles, which are recovered from the backyard, how does that help you decide what specific acts this young man committed, if any, or what his state of mind was at the time? You heard evidence about an unfired .40 caliber round found on the ground near Mr. Henry's body, right? We know that that is a .40 caliber Perfecta round. It's the same make and caliber as the rounds that are found inside the Glock with the extended magazine at Mohawk, and the same make and caliber as the rounds found in a separate Glock compatible magazine in Mr. Vasata's pocket. The state had a lot to talk about how that unspent bullet got there. Do we know how it got there? I can't imagine how we would know how it got there based on the evidence in this case. What does it being there? What does it being there next to Mr. Henry, what does it tell you? What conclusions are you supposed to draw from that? It doesn't have Mr. Vasata's DNA on it. It doesn't have his fingerprints on it. I mean, if we're going to speculate, could he maybe have handled that round with or without gloves and not left his DNA or fingerprints on it? Sure, maybe. Could he have not touched that round ever once in his whole life? Could he not have been the one that loaded it into the extended magazine? The extended magazine, which also doesn't have his DNA, fingerprints, or his blood on it. Sure. That's as likely a possibility as whatever conclusion the state is asking you to conclude. Now, before we move on to talk about what items of evidence were found at the scene at Paseos Way, let's go through what we learned from the two medical examiners and from Omar Felix about the bullets and projectiles recovered from the bodies of the decedents. And let's talk about Ms. El-Salahi first. She appears to have been shot 5 times. According to Dr. McDougall, the exit wounds on the front of her torso are consistent with high-velocity rounds which come from a rifle. So is the fragmenting of projectiles from her abdominal area. Both of the doctors and Omar Felix agreed is common to occur with high-velocity rifle rounds. None of the multiple fragments and pieces that were recovered from Ms. El-Salahi by Dr. McDougall during that autopsy were examined by Omar Felix. But McDougall seemed more comfortable here on this witness stand attributing those exit wounds as being caused by a rifle round than she was with some of the gunshot wounds to Ms. Doherty. which we'll talk about momentarily. Ultimately, you get to decide what you can determine from these injuries based off the evidence and testimony you heard. I believe you will determine to be true exactly what the evidence in this case shows to be true. Namely, that Miss El-Salhi was shot and killed by the one and only rifle involved in this case, by the rifle in evidence, by the rifle that Luke Kasuchos fired 17 times without warning and without direction or assistance from Mr. Vasata to begin firing that gun. Miss El-Salhi was shot by the same rifle that Luke Kasuchos shot Mr. Vasata with, twice in the back, nearly killing him in the process. You ultimately have to ask yourself how this evidence helps you determine whether Mr. Vasata intended for Mr. Kasuchos to kill Miss El-Salhi, and whether these facts help you determine if Mr. Vasata did or said anything to aid or direct him to fire that gun. Now, it's clear the state wants to leave open the possibility that Miss El-Salhi may have been shot with the Glock pistol also, and by Mr. Vasata, they would likely speculate. 5 shell casings in the back of Mohawk. 5 .40 caliber shell casings. It means 5 .40 caliber shots fired in the backyard. 2 .40 caliber projectiles. 2 of those go with 2 of the shell casings. There's one in Mr. Henry's arm. There's another in his back muscle that I can't pronounce. There are 2 through and through gunshot wounds to Mr. Henry's head. The doctor calls them perforating. That means there's not a projectile recovered from this. That's 4 .40 caliber projectiles. There's 2 .40 caliber projectiles that are found in the yard. Where's the projectiles that struck Miss El-Salhi? There aren't any from a .40 caliber gun. And ultimately, if you determine that the state has not proved beyond a reasonable doubt that Christopher Vasata himself shot and killed Brandy El-Salhi, you'll have to look at the principal theory instruction. And we'll talk more about that theory later. Miss Doherty has what appear to be 4 gunshot wounds. The most serious gunshot wound, according to the doctors, was to her torso. It's the one which was fatal. This was a projectile that entered into her left shoulder with the velocity to travel through her entire body before being lodged in her scapula. They recovered that projectile during the autopsy. We know that that shot was fired from a rifle. That rifle. The rifle that in that same 6 to 7 seconds shot this young man in the back twice. The state wants to tell you maybe Mr. Vasata shot the gun and the rifle? Are you kidding me? You heard from Mr. Vorpagel, this happened in 6 to 7 seconds, 22 shots. Are they honestly asking you to consider the possibility that Mr. Vasata, in 6 to 7 seconds, managed to not only fire a Glock pistol, which they don't have evidence to support, but that he also managed to fire a rifle and give it to someone else who then shot him in the back twice? Dr. McDougall said she couldn't be 100% sure whether the projectile from Miss Doherty's shoulder blade, that's what a scapula is, whether it was fired from a rifle or another gun. Just like she couldn't be 100% sure about Miss El-Salhi. Omar Felix, using a comparison microscope, concluded that that bullet was fired by the rifle. Miss Doherty has wounds where a bullet traveled through the large chin portion of her jawbone, her mandible, exited entirely through that large bone, re-entered her right chest before shattering her humerus bone and exiting out of her arm on the right side. It left a large, gaping exit wound. Dr. McDougall was reluctant to conclude that a rifle must have fired this shot. She didn't want to say it. If you need to, look at the exit wound on Miss Doherty's right shoulder. Compare it to the large exit wounds on Sean Henry's right torso. Compared to the large exit wounds on Miss El-Sahi, which Dr. McDougall felt were consistent and easier to attribute to a rifle. Compare it to the exit wounds on Mr. Vasata's body. Those images are there for you to look at if you need to. Consider that the bullet which traveled through Miss Doherty's chin, ultimately exiting out of her arm, comes from the same direction as the bullet, which we know came from the rifle, entered her arm, and lodged in her scapula and her back. Now, Miss Doherty has a couple other injuries. There's a particularly unpleasant wound, though not likely fatal, to her right forearm. A wound which would also be consistent with a high-powered rifle, although no one can be 100% sure because no projectile was recovered from that wound. Lastly, she has a wound to her left hand that no projectile was recovered from. And it's impossible to say, for anyone to say, what caused the medically superficial wound to her left hand. Like with Miss El-Sahi, the evidence in this case shows that Miss Doherty was shot with and killed by the rifle in this case. The rifle that Luke Kasukos shot 4 people with, including Mr. Vasata. And again, if you determine that Mr. Vasata is not the one that killed Kelly Doherty, your duty is to look at the principal instruction. And we'll talk a little bit more about that. Now, to learn about Mr. Henry's injuries, we heard from Dr. Gertrude Just. And Dr. Just apparently didn't like having to answer my questions. You can look at the weighing the evidence instruction in your packet, page 34, and you can decide for yourself whether the doctor was honest and straightforward in answering my questions. You were sitting right here. You saw her demeanor and her attitude. You can decide whether she has an interest in how this case was decided and whether she made a statement at some point in time that was inconsistent with what she said in court. I want to talk about what I was ultimately able to get out of her when she did actually answer the specific questions that I asked her. Now, depending on which answers of Dr. Just you believe, Mr. Henry was shot 12 times or 17 times. Dr. Just told all of us that it doesn't matter. But you are all the ones who get to decide what matters. We know that Mr. Henry was shot twice in the head. We know that there were no projectiles recovered from inside of his head, although there were fragments recovered that were not examined by Mr. Felix. We don't know what position Mr. Henry was in when those wounds were inflicted. Dr. Just said she believed the 2 gunshot wounds to Mr. Henry's head were from a pistol, not a rifle. And she told us that one of them was a close range but not contact wound. She described how the wound was surrounded by stippling and soot. And we know from what Omar Felix explained to us that soot, smoke, and gunpowder exit out of the muzzle of a firearm when it is fired, and that the same explosion which propels the bullet out of the barrel is the same explosion that causes the casing to eject from the firearm. What do we make of this evidence? What conclusions can we draw? Well, there hasn't been any evidence that Mr. Vasata or any gloves or clothing that he may have had on had any DNA on them from Mr. Henry's blood from that close-range shot. We haven't heard any evidence that any of the soot or gunpowder residue found on Mr. Henry's head was also found on the gloves or clothing of Mr. Vasata. When the sum of the evidence shows that there are at least 3 people, including Mr. Vasata, who went armed to 1105 Mohawk, how do you determine who fired these pistol rounds into Mr. Henry? The state says it doesn't matter. The law disagrees with the state because it does matter. To find a person guilty of a crime, you either find beyond a reasonable doubt to your moral certainty that that person themselves actually committed that crime, or you find that the state has proved to you with evidence, not speculation and hypothesis, but evidence, that the defendant, in this case Mr. Vasata, intended for that to happen and did or said something to help that happen. If you speculate and assume the worst possible explanation, despite being told to presume innocence, then maybe you could. What we do, in fact, know is that there were 2 .40 caliber projectiles recovered from Mr. Henry's body. We know that one, as I said before, was in his back, and one recovered just under the skin of his left arm. Ask yourself, who fired those shots? I would suspect the state would argue that the Taurus revolver didn't fire any rounds, so therefore they had to be from the Glock. And because Mr. Vasata was ultimately found with a separate Glock magazine in his shorts pocket, that he therefore fired those shots. If you are comfortable and confident taking the logical leaps necessary to reach that conclusion, you're the jury. I just ask that you base your conclusions on the evidence and what it tells you. What doesn't take a great deal of assumption and speculation is the conclusion that Mr. Henry was also shot with the rifle. If you need to, look at the wounds to his right torso and his right arm. The injuries to his right torso, at least one of which is labeled wound R, letter R, was described by Dr. Juice as an exit wound. And it looks like the other exits from the rifle we have seen on Miss El-Sahi, Miss Doherty, and Mr. Vasata. We also know that a deformed metal jacketed bullet was recovered from wound E on Mr. Henry's upper right chest. And there were photographs introduced in evidence by the state on June 12th as states 228 and 230. I think there were photographs of the projectiles that were recovered from Mr. Henry. 228 is a close-up view of the fragment taken from gunshot wound to E. We know that Mr. Felix was never given any of these items, so he can't tell you whether he could or could not make a comparison to the rifle. Take a close look when you get back there, if it matters to you, if you think it's important, and I think it is, which is why I'm talking to you about it. But if it matters to you who killed Sean Henry, take a close look at the tip of the projectile. It's right here, near the word metric on this scale. And ask yourself if you don't think it has the exact same narrow tip of a .7.62 rifle cartridge as the ones that are in evidence, the intact cartridges that haven't been fired. And if you don't think it does, then you're the jury and you get to decide that. As to the rest of these fragments, which were not examined by Omar Felix, what did Dr. Juice say about the fragments recovered from Mr. Henry's body? She said, usually handgun bullets are recognizable, as opposed to fragmentation that you would see with rifle rounds. These projectiles and fragments are consistent with a rifle. A rifle that we know Mr. Vasata didn't fire. With Mr. Henry's injuries and the bullets and fragments recovered from his body, you will again ultimately have to ask yourself, how does this help determine who fired these shots? Was it Mr. Vasata? Was it Mr. Kasukos? Which up until today, during the course of this trial, the state acted as though the notion that Luke Kasukos was involved in this was lunacy, really, some kind of fabrication that the defense came up with, even though it's their evidence that suggests it, right? Was it Marcus Stewart who fired the shots that killed Sean Henry? If you can look at this evidence, even in conjunction with the other evidence in this case, and conclude to a moral certainty amongst each and every one of you that Mr. Vasata fired any of these shots himself, including the shots which came from the rifle that shot Mr. Vasata in the back, you're the jury. You get to make that decision. You get to decide which logical leaps to take and which not to. And if you decide that you're simply unable to determine beyond a reasonable doubt whether Mr. Vasata fired the rounds, which Dr. Juice says came from the pistol, and which obviously killed Mr. Henry when they went inside his head, you will have to ultimately decide whether and how Mr. Vasata could be responsible under the law regarding principal liability for shots that were fired by someone else. Let's talk about the evidence that's recovered at Paseos Way. That's where the BMW was found, as you all recall, I'm sure. Let's talk about where that is in the first place. This is States 88. It's an aerial view of that part of Jupiter. Shows you Paseos Way down here. Jupiter River Estates up here. Now, Miss Ridgestone has provided you a compelling story about what happened. A work of speculation to some extent, a work of truth to some extent. Why park at Paseos? The state's argument is that if you park at Paseos, a distance away from where Mr. Vorpagel lived, therefore you intended to kill them. If you think that's a fair variety of reasoning to decide this young man's fate, no one is going to be able to stop you from doing that. If that's the lens that you want to look at every fact in this case and decide to reach the worst possible conclusion of any, you're not supposed to do that, but nobody can stop you from doing that. Mr. Vasata and other individuals. There's no evidence, there's been no assertion by the defense that Mr. Vasata went over there with an innocent purpose. Your decision making isn't, did Christopher go there with either an innocent purpose or a premeditated intention to kill? Right? It's not an all or nothing decision that you make. is the decision to park far away from Charlie Vorpagel's house and to walk through darkness along this path into that neighborhood. Is that consistent with going to Mr. Vorpagel's house armed due to the nature of the armaments at Mr. Vorpagel's house? Is that consistent with an intention to scare Mr. Vorpagel, to intimidate Mr. Vorpagel, to threaten Mr. Vorpagel? Because people were, in fact, murdered that night, it is the human temptation to assume that parking away from his residence is evidence of a premeditated intent to kill. People conceal their movements. People avoid law enforcement when they're engaged in all sorts of activity that falls far short of premeditated murder. Had no one been shot and killed, but people had been threatened with firearms that had been brandished at people, that's against the law. People go to prison for that. Is it ludicrous? As I'm sure the state will tell you that this is ludicrous. Is this ludicrous that Mr. Vasata and those individuals parked in that location to commit an aggravated assault, to commit a robbery, to threaten, to intimidate, and that they dressed the way they did in order to look the part of someone who means business, someone who you should be scared of? The state's also told you this compelling story based on the timeline and has asked me to draw a conclusion that necessarily Mr. Vasata, Mr. Stewart, you can probably see that Mr. Vasukos also, got there 30, 40 minutes in advance. And the state paints this picture of hiding in the bushes, ambushing, right? Scary words, if that's what happened, right? If that's what happened. The state told you that nobody was even home when Mr. Vasata and the others got there. Based on what? Based on Charlie Vorpagel saying that? If you recall, Detective Bujanowski, he was kind of a helper to Detective Hirsch. He went and recovered surveillance videos and other items of evidence when they were sort of just gathering up materials for this investigation. What did he testify about? He testified that he obtained a surveillance video from Citgo, a gas station in Jupiter near where Mr. Vorpagel lives, and that the girls, Brandy Elsahi and Kelly Doherty, were at that gas station at 7:43 p.m. What were they doing there? Well, they were getting what Charlie asked them to get and bring to his house: beer and cigarettes. That's what Detective Bujanowski, he said right there. He told you the girls bought beer and cigarettes at a nearby Citgo at 7:43 p.m. Charlie Vorpagel told you he texted the girls and asked them to pick those things up shortly before they came to his house. Charlie Vorpagel told you that he got to the house right as the girls got there, or shortly thereafter, right? Said they were still in the driveway when he pulled up. Charlie Vorpagel tells you that that was at 10-something. Who are you going to believe? Are you going to believe Detective Bujanowski when he says what the time was? Or are you going to believe Charlie Vorpagel who'd been drinking for, I don't know, since he woke up at whatever time that was, 2, who'd been taking Xanax. He's got hundreds of them in his house, smoking weed, taking ecstasy, snorting cocaine. Whose sense of time you think you should rely on in that? You know, and ultimately, it may not matter to you. You may say, for my decision-making, based on what I believe the evidence shows in this case, it doesn't matter whether anyone was home when Mr. Vasata and the others arrived or not. But let's be clear about what the evidence is versus what's just the work of fiction and the work of the prosecutor's imagination. What evidence? Things you can see and hear and touch, things you can rely on, things you can say, I'm comfortable with that decision because I can look at that thing right there and say, I'm confident. What evidence is there to support this wicked story? Let's talk about the evidence in and around the BMW that's found in Paseos. We know that Mr. Vasata's driver's license, his debit card, and it's not an airline ticket, it's a baggage receipt. I'm assuming most or all of you have flown before on a plane and they give you a receipt when you check your bag. That's what it is. This isn't an airline ticket to flee town. It's in evidence if you want to look at it. It's got Mr. Vasata's name on it. You also know in that car there's business cards from Luke Kasukos and his business Luxuria Automotive Club. Mr. Vasata's stuff is on the driver's side door. We know that Mr. Stewart's cell phones are in the passenger area. We know that there were water bottles in the passenger area next to the 7.62 rounds that were fired from the rifle. I'm sorry, that were compatible with the rifle. There were water bottles inside that vehicle, which were swabbed but not tested. We won't know if Luke Kasukos' DNA is on that or not. The state has emphasized that he's been excluded from everything. Well, use your common sense and your fair judgment. Everything they tested, right? He's excluded from what they tested. Now, the sock of ammunition that's found in the passenger door of that vehicle, not in the driver door where Mr. Vasata's items were, that ammo doesn't have Mr. Vasata's DNA on it. No evidence presented of that or of his DNA on the cartridges inside. Ultimately, does the ammunition found in the passenger door of that BMW, does it belong to Luke? Does it belong to Marcus? Who I guess according to the state's theory would have been riding in the passenger seat because Mr. Vasata was driving? Or does it belong to Mr. Vasata? Does the answer help you decide whether Mr. Vasata went to 1105 Mohawk with these other young men to kill or to confront? Think if Mr. Vorpagel had done what he wanted to see happen. Think if he had gone and killed Mr. Kasukos. Think if he had taken a firearm to go threaten or intimidate Mr. Kasukos. And in the course of that, he or another person started shooting and killed people. What would the evidence in Mr. Vorpagel's house make it look like? Would that be evidence that he premeditated a murder, even if he never intended that to happen? Do the answers to the question about that 7.62 ammo in the car, does that tell you or help you decide whether Mr. Vasata went to 1105 Mohawk with these other young men to kill them or to confront them? To kill them, or to scare them? To kill them or to intimidate them? Does the fact that a person brings a firearm to a location where they anticipate having a potential altercation, right? Not planning it, but considering it as something that could happen, which is why they're bringing a firearm, because the people they're going to see are armed to the teeth. Do you assume that that person intended a murder just because ultimately 3 people did get killed? Does the fact that something ultimately happened mean that it happened because someone intended it to? There's a backpack found inside the BMW. That backpack, which contained bullets and a magazine, 7.62 rounds in it, there's no DNA on that backpack. State says it's in Mr. Vasata's car. Marcus Stewart was in there. You don't know Marcus Stewart either. Lucas Sukos is in there with his stuff. There's no DNA of Mr. Vasata's on that backpack. The ammunition that's inside that backpack, those .40 caliber rounds, there's no DNA or fingerprint evidence on those items to definitively tell you Mr. Vasata ever touched those bullets from the backpack. The rifle magazine that was found in the backpack, which is submission 27, and that'll be on the photographs and on the actual exhibit itself in evidence, not to be confused with submission 28, which was the magazine that our masked agent ultimately removed from it and testified about. That's submission 28. The state's evidence doesn't connect Mr. Vasata to the magazine that was in the backpack. If the magazine's not his, whose is it? Stewart's? Sukos's? Even if Mr. Vasata knew that they had those items, does it mean he intended for those individuals to kill people? Same thing with the .357 rounds that are found inside that backpack. Those are consistent with the rounds in the Taurus. The Taurus that Marcus Stewart took and hid under the culvert near I-95. There's no DNA or fingerprints for Mr. Vasata on those items. Whose are they? The rifle bag, found in the car, in the back seat, behind the driver's seat. Mr. Vasata's DNA is not on that bag. His DNA isn't on that bag. Whose bag is it? Does the bag being in a car that Mr. Vasata rented from Luke Kasukos mean that the bag is his? If it's not Mr. Vasata's rifle bag, whose is it? And if it's not his rifle, how does his DNA get on it? Does it transfer? It's hard to say. The DNA expert doesn't know. There's also a plastic t-shirt bag inside that car, and the state has talked about how there are 3 t-shirts. And we'll shortly look at what the evidence says regarding whether Mr. Vasata was ever wearing one of these t-shirts. We know he wasn't found with one on when we talk about what's located in the Honda. Now, there was a glove in the road under where Mr. Vasata was found when he was dumped out of that car. The state never bothered to test that glove for DNA. If it ended up having Mr. Vasata's DNA on it, wouldn't be that surprising, right? It's found under his bleeding body on Paseos Way. Do we know for certain that Mr. Vasata wore that glove? No? You may conclude that. Does it ultimately matter? Does the fact that Mr. Vasata may or may not have worn gloves, does that mean that he intended to kill someone? There's an argument for it, right? The state's made it. They'll continue to make it. Why would you wear gloves if you weren't trying to kill someone? Would you wear gloves to look scary? Would you wear gloves to prevent your biological evidence getting on a gun that you used to threaten and intimidate a person with, a criminal act, an aggravated assault that will send you to prison? Yeah. The state's grand theory is that Mr. Vasata, Marcus Stewart, and I guess now Luke Kasukos too, walked under the cover of darkness, plotting all the way to murder these people after parking a distance away, wearing black hoodies, black gloves, and carrying guns. They've also said masks. I just asked you, where are the masks? in this case? What evidence of masks are there? The state, of course, believes this is crystal clear proof. They went to the house at Mohawk to murder people. And if you want to jump to that speculative conclusion, you all are the ones that get to make those decisions. Now, the magazine and bullet that are found in Mr. Vasata's pocket, Deputy Householder rummages through his shorts pocket, not black pants, just shorts. She locates a .40 caliber. I don't know if it's a Glock brand or Glock compatible magazine. I'm not sure. It's in evidence if you need to look at it. As she explained, that magazine could be used in any Glock 23 firearm in the world. That magazine has Mr. Vasata's DNA on it. Of course it does. The state gets up here and gestures and says it's his touch DNA. Is that what the evidence was in this case? Did you hear from a serologist or a DNA expert that says, we definitively concluded that the DNA that was on that magazine was epithelial skin cell DNA? They didn't, because they don't know. State talks about on this piece of evidence and on the frame and receiver of that rifle, says it's not Christopher Vasata's blood on there. It can't be. It's not what the experts say, right? The state says you can't see it. They ask experts, can you see it? Can you see it? No, I can't see it. 50 cells is what is required to develop a DNA profile that could be used to compare, match, and exclude an individual who you have a DNA profile from. Miss Margetts, what'd she say? You can't see 50 cells. You know that with common sense. That's why we have microscopes, right? You also recall Miss Margetts said on that magazine that's in Mr. Vasata's pocket that it has three contributors. Three contributors. It means DNA from 3 different people on that magazine. The state talks about 77% of the DNA obtained from the magazine was from Mr. Vasata. I assume you all appreciate that the amount of DNA that we're talking about is beyond microscopic. This is what's extracted from the nucleus of cells that you can't even see. We're talking about an infinitesimally small amount of biological material. The state loves 77%. That's the number. 77% of what? Less than that. 77% of nothing. Don't be misled. Remember what the expert said about the science. This is microscopic. It's not fair or reasonable to conclude that that magazine, because it has 77% of the DNA from Mr. Vasata and that 15% is from an unidentified contributor and 8% from a third unidentified contributor, that Mr. Vasata has handled that magazine throughout its lifetime for 77% of the time. It's a clever argument. It's inaccurate and misleading. Remember the science, please. What we don't know is if the blood on the magazine came from the DNA on the magazine came from blood. It would make sense that his blood is on it. It's in his pocket. He's laying in the roadway. He's bleeding profusely. He has to have emergency surgery to save his life. The back of the Honda automobile is covered in blood. It is not surprising that that's in his pocket. I'm sorry, that that's covered in blood. Now, ultimately, the state says he has that magazine in his pocket. That's the extra ammo for the extended magazine. Therefore, he's the one that had the Glock with the extended magazine. Is it proof that Mr. Vasata was carrying or brandishing the actual Glock that's found in the backyard? Is it evidence that he carried the magazine for someone else? Is it evidence that he was given the magazine by someone to hold? Is there any way to know? The state's going to tell you, use your common sense. Common sense. That's code for assume. assume. Take that logical leap. And if you're comfortable doing that with what's at stake in this case, nobody can stop you. Now, under any of those scenarios, what does Mr. Vasata, having that magazine in his pocket, tell you about whether he had a premeditated intent to kill that night? If Mr. Vasata went along with Marcus Stewart and Luke Kasukos that night to scare and intimidate Charles Vorpagel and Sean Henry, individuals that Luke Kasukos certainly had a motive to commit violence against, if he went along with those individuals to intimidate and threaten Charles Vorpagel and Sean Henry, two guys were drugged up, pulled up in what is, according to Teresa Bryant, like the SWAT armory at the Jupiter Police Department. Does the fact that Mr. Vasata or those young men he was with went armed, does that mean that Mr. Vasata, that this young man here, had in his mind and in his heart a conscious, fully formed decision to kill people? If you believe that that is supported by evidence and not speculation and hypothesis, then you're the jury. You're the only ones that we're trusting to make this decision. I want to talk very briefly with you about the I-95 scene. Again, there's no masks that are located in there. We know that there are 3 T-shirts. I don't know what that tells you about premeditation. It tells you something about the number of people involved. You learned that there's DNA all over the inside of that Honda. You learned that the steering wheel, that Mr. Vasata's DNA is on that steering wheel. That Marcus Stewart's DNA is not. Right? Well, we know that Mr. Vasata wasn't driving that car. There's a video that is in evidence, and you've seen, that shows him being dumped out of the back seat of that car. And we know his DNA got on the steering wheel by transfer. Right? The experts said this is a real thing that happens with biological material, which is why they ordinarily, not necessarily in this case, but ordinarily take great measures to make sure that evidence isn't commingled, so that one piece of evidence doesn't transfer biological material to another. Now, the black T-shirts that were found in the Honda, you get to make of this evidence what you want. You get to assign the weight and value to these items of evidence that you think that they can bear, that you think that the evidence supports. If wearing a black T-shirt, which one of those black T-shirts has Mr. Vasata's DNA on it, the one from the back seat where Mr. Vasata's blood is all over the place, remember 50 cells is what it takes. If you believe that he was wearing that T-shirt, you can conclude that. If you believe that wearing a black T-shirt and a black hoodie and black gloves is proof beyond and to the exclusion of any reasonable doubt as to whether there were other reasons for those individuals to go to that house besides murder, then that's the way that you should view that evidence. Now, the gloves from the culvert, we know that those are Mr. Stewart's gloves, right? And we know that Mr. Vasata's blood is on it. The major profile from submission 18A is from Mr. Vasata. I'm sorry, 18A and 18B, the gloves from the culvert, those are the Mr. Stewart's gloves. They have his DNA on it. They have Mr. Vasata's DNA on them from blood, from when Mr. Stewart carried and placed Mr. Vasata into the Honda. There's no evidence that Christopher wore either of those gloves. There's a Taurus revolver, which appears to have not been fired during the incident in the back of 1105 Mohawk. There's two people's DNA on that gun. None of it was compared to anyone else. Do we know if Mr. Vasata had the revolver? If he's one that didn't shoot someone? The state will say, you couldn't have the revolver if you had the .40 magazine in the pocket. Is there any evidence that that .40 magazine went to that gun? Right? If it did, is there any evidence that proves Mr. Vasata had the .40 Glock pistol? There's a rifle recovered from the culvert, right? We call it an assault rifle. You can call it whatever name you want. This is a device that someone shot 17 times in 6 seconds without warning to anyone. They swabbed some areas on that firearm. They swabbed the trigger and the trigger. I'm sorry, the trigger, right? Mr. Vasata's DNA is not on that. State will say, oh, he had gloves on. They also want you to say that that's his rifle and that's his rifle bag in the car. Yet his DNA is not on that. The magazine that's taken from the rifle, the magazine that has all of those unfired rounds in it, Mr. Vasata's DNA is not on that magazine. It's not on any of the rounds. The frame receiver portion of that rifle. This portion here is the center of gravity of that gun. That is the heaviest portion of that gun. There were 3 contributors to the DNA profile obtained from that area. Not from the trigger, not from the trigger guard, not from the grip, from the frame and receiver. That means 3 people's DNA is on that gun. The state is insistent that Mr. Vasata's DNA on that gun is touch DNA. Because Ms. DaCosta, the serologist, said that a cotton swab Q-tip was not discolored. A Q-tip that was run across the firearm, which has been fired 17 times in rapid succession. Is there gunpowder on there? Right, they have pictures and evidence from some of the sweatshirts, that from the sweatshirt that has so much blood on it. And there's a picture of a cotton swab next to it that shows this presumptive testing, shows this color. Do you think 50 blood cells, 100 blood cells, 500 blood cells that are so small the human eye cannot see them, that requires a microscope in a laboratory to detect, do you think that that number of blood cells would make a Q-tip look reddish? The state points out that 69%, the minuscule amount of DNA that's found from that frame or receiver of that rifle is from Mr. Vasata. Don't be misled by these numbers. His DNA is on it. We know he didn't fire this gun. You know it. It's impossible. You can't shoot yourself in the back with that gun twice. Ultimately, there was no serological testing done of the DNA swabs from that firearm. The last thing that was recovered from I-95 was the hoodie from underneath the culvert. This is a sweatshirt that apparently Marcus Stewart attempted to hide under the culvert. He attempted to hide these items. He attempted to flee. And of course, the state argues that these actions that occur after, that we should take the guilty mind that a person has after the fact when something like this happens, and we should just try to take it back in time and say that it existed at the time of the killing. If you're comfortable with that, you can do that. That's one way to look at things. It's one way to think of the evidence. You can also ask yourself, what do Marcus Stewart's actions, fleeing, hiding things, what do his actions after this happened tell you about Christopher's intentions before this happened? A fully formed, premeditated intent to kill must be before the killing. If things go awry, people get killed, and you freak out afterwards, that doesn't tell you anything about a person's intention before things went awry. Just a few more minutes, folks, and I appreciate your attention. I know you're getting hungry. The state talked about Christopher's statements to Detective Hirsch at the hospital. Actually, before I get there, to back up to the items recovered from the culvert, for what you would make of it, the BMW key fob, which goes to the BMW, was found in Marcus Stewart's sweatshirt. Does that tell you what the plan was in the beginning? Does it tell you what Mr. Vasata's role was in that plan? It tells you that he didn't have it on him when he's found, and it tells you that he likely didn't have it on him at the scene. Now, when Detective Hirsch spoke to Mr. Vasata, you heard what she told you he said, right? He says some things that aren't true, right? Is he lying when he said he was at his buddy's house? Ms. Ramsey talked about the relationship between Mr. Vorpagel and Mr. Vasata, and I don't know if that's a lie or not. He said some things that weren't true. The state says this clearly tells you his guilt. If you think that, I can't stop you from thinking that. If you think that the evidence deserves that huge leap to say the fact that he lied to the detective about why he was over there, that means he went over there with a fully formed, premeditated intent to kill, you can reach that conclusion. Is this really reliable as to consciousness of guilt, as to premeditated first-degree murder? Would someone young like Mr. Vasata, who was involved in something illegal, threatening and intimidating others with weapons, be just as likely to want to distance themselves from what had happened? Especially when they were there and not only heard the 22 shots that were fired, but felt 2 rifle rounds blast through their body. The state says this is some kind of conniving, sophisticated ruse to throw investigators off of Mr. Vasata's tail. But you know what? You get to decide if that's what it was, or if it was just some scared and gravely injured young man trying to distance himself from something that he got in that was way over his head. You're the jury. You get to decide that. I'm going to take just a couple brief moments with the verdict form. As we talked about in jury selection, and as the judge has instructed you, your duty is going to be to make an independent, separate determination for each of these. Sorry, I'm underway. For each of the offenses. And as the state pointed out, the judge will tell you, you go through count 1 first, then count 2, then count 3. You start at the top. You need to make a decision about first-degree murder. Count 1 in this case is Sean Henry. Right? You've heard that he was shot with a pistol and with a rifle. And you will ultimately have to decide amongst all of you whether the proof in this case, the evidence, not speculation, but the proof, the evidence, if that convinces you that Mr. Vasata himself fired one of those guns that shot and killed Mr. Henry, and he did so with a premeditated intent to kill, then that's your verdict. I think it's 2 more minutes, thank you. And then you answer the interrogatories. If you have doubts about that, unanswered questions, you ask yourself about second-degree murder, which Ms. Ramsey talked about the intent that's required for that. If that's your verdict, based on evidence and proof, not assumptions, not speculation, then that's your verdict, and you answer these questions. The state talked dismissively of second-degree murder, said, as for bar fights, that's for you to decide. The elements are instructed in the packet that you have, and you get to decide. So for each of these, count 1, count 2, count 3, count 4, count 5, did Mr. Vasata commit the crime himself? If not, that's not guilty. Yesterday when the judge went through this, I don't think he said that. For each of these, right? There's a dispute in this case. A dispute about the evidence, a dispute about what the evidence means, which is why we need you to decide it. You know, we talk so much about penalty and different things ahead of time. We talked about all of this stuff. And the state talks with this anger, which is understandable about what happened. But there's a real dispute about the evidence in this case. If you believe that Mr. Vasata is not guilty of any of these offenses, by following the law, by following your common sense and your sense of fair judgment, that's your verdict. Now for to talk about count 1, if you find that Mr. Vasata did not shoot a firearm that killed Sean Henry, the only way that you could find him guilty of a homicide offense, first-degree murder, second-degree murder, or manslaughter, is under principles theory. It's page 4 in your packet. Again, principles. We talked about this in jury selection a lot with you guys. This was weeks ago, but does the fact that somebody went with somebody else to do something that you all don't approve of, that you wouldn't do, that I wouldn't do, does that make the person responsible for a murder that's committed during the course of it by someone else? You all swore that you would uphold the law. This is what the law is. To be guilty as a principle, the state has to prove that the defendant had a conscious intent that the criminal act be done, right? So for first-degree murder, the conscious intent for that criminal act is premeditation. The conscious intent for second-degree murder is a depraved, evil, wicked intent. And 2, under principles, that the defendant did or said something. If Mr. Vasata handed someone a gun, drove people in a vehicle that contained guns, to get involved in this incident, to threaten and intimidate these individuals, but without any premeditated intention to kill, without any intention to kill whatsoever, he's not guilty under principle theory. Now on counts 2 and 3 with Ms. El Salhi and Ms. Doherty, there's one other twist to this, right? First, you decide, has the state proven beyond a reasonable doubt that Mr. Vasata actually killed either one of those young ladies? And two, was there a premeditated intent to do so, right? If you decide those things, that's your verdict. If you say, hey, I don't care what the evidence is, I think Mr. Vasata himself fired that rifle, we leave these decisions to you. If you say, the evidence is fairly clear that Ms. El-Sahi and Ms. Doherty were killed by the rifle in this case, by Lucas Sukos, presumably. I guess Marcus Stewart could have had the rifle, although that's not what Mr. Vorpagel described. If you determine that Mr. Vasata did not fire the weapons that killed Ms. Doherty and Ms. El-Sahi, again, you go to principle theory and say, did he intend their deaths? Did he intend for them to get killed and to wind up on photos in court, their lifeless bodies, and their grieving families? Did he intend that? Without knowing they'd be there? If you believe he did, and you believe that he did or said something that was with an intention that the killing occur, then that's your verdict. If you don't, then under principle theory, he's not guilty of their murders. There's one other instruction that pertains to your decision on Ms. Sahi and Ms. Doherty, and that is, it's under the first-degree murder instruction. It's 7.2, the one for Ms. El-Sahi, because you have one for her and for Ms. Doherty. It's page 13 for Ms. El-Sahi. Underneath the definition of killing with premeditation, which defines what is required in order to find premeditation, it says if the defendant, that means if this young man here had a premeditated design to kill one person, and in attempting to kill that person actually kills another person, the killing is premeditated. If you look carefully, you'll notice that on the instruction for Sean Henry under first-degree murder, this is not there. It's called transferred intent. Under these instructions, these laws that you've sworn to follow in this case, Mr. Vasata cannot be found guilty of murdering Sean Henry under this transferred intent theory. If, however, you believe that Ms. El-Sahi and Ms. Doherty, who appear to have been shot and killed with that rifle, if you believe that Mr. Vasata had that rifle and was trying to kill Charlie or Sean, but instead shot and killed the girls, then you could find him guilty under this transferred intent theory of premeditated murder. But you know he didn't have the rifle, so you know you're not going to do that, which is why the state wants to leave open the possibility that they may have been shot with the .40 also, despite the fact that there's no evidence that that's what happened. Ladies and gentlemen, I appreciate your attention and your patience and your long and careful consideration in this case in making this difficult decision. We ask that you find Mr. Vasata not guilty of murdering Sean Henry, not guilty of murdering Brandy El-Sahi, not guilty of murdering Kelly Doherty, and to find him not guilty of stealing that car.